You're driving home from dinner. Maybe you had a glass of wine 2 hours ago. You feel completely fine. But then you see those lights in your rearview mirror. You pull over, hands on the wheel, heart pounding. The cop walks up to your window, and before you can even hand him your license, he leans in and says the 5 words that completely ruin your night. I think I smell alcohol. Here's the thing. What you say in the next few seconds will determine whether you get to drive home or end up in handcuffs in the back of a squad car. And the answer most people give is the single biggest mistake I've seen people make in 22 years of defending DWI cases. It's so bad that by the end of this video, you're going to be shocked that people still fall for it. But I'm not just going to give you the mistake. I'm going to give you the exact script, word for word, that puts the law on your side. These words make the officer's job 10 times harder, and I've got the actual case law to back it up. Hi, I'm Ethan Holloway, former prosecutor turned defender of the people. Let's jump right in. Here's what most people don't realize. When a cop says, I smell alcohol, that's not an observation. That's a trap. Because let me ask you this. Does alcohol smell? No, it doesn't. Alcohol is odorless. What you smell is the beverage the alcohol was in. The hops in the beer, the grapes in the wine, the barley in the whiskey. Pure ethanol has no odor, and cops know it. This is a specific interrogation technique taught at the academy. Let me show you exactly how this trap works. Think about it from the officer's perspective. He walks up to your window. He does not know if you've had 0 drinks or 10 drinks. But the moment he says, I think I smell alcohol, what does every person want to do? They want to explain. They want to defend themselves. Oh, officer, I only had 1 beer. I had dinner 3 hours ago. I'm totally fine. Smell my breath. I promise I'm not drunk. They think they're being cooperative. They think they're going to talk their way out of it. But here's what's actually happening. Every word out of your mouth is being recorded, cataloged, and planned on being used against you. When you say, I only had 1 beer, that's not a defense. That's an admission. When you say, I had dinner 3 hours ago, not only is that an admission, it's something they can use to calculate your blood alcohol level on the witness stand. When you say, smell my breath, I promise I'm not drunk. Congratulations, you just consented to a search. You're handing the cops a DWI on a silver platter, and the officer knows it. Put yourself in the mind of that police officer for a second. DWI investigations are routine for them. It is no different than you waking up and making breakfast before work. That's what they do every single day. They are not really open to you convincing them to let you go. What they are doing is making you feel like there's a chance they might let you go because they are trying to gather as much evidence from you as possible before the cuffs come out. So trying to talk your way out of a DWI almost never works, and it almost always hurts. Now understand what the officer is actually looking for. DWI police reports have rubber-stamped sections officers literally check off: physical signs, strong odor of an alcoholic beverage. They even grade it strong, moderate, or light. Slurred speech, unsteady on your feet, bloodshot, watery eyes. And here's the problem. Tired eyes look the same as intoxicated eyes. Allergies look the same. A double shift at work looks the same. The officer marks it down as a sign of intoxication regardless. Mental signs, confusion, unable to find or hand over your ID or insurance, attitude problems, unable to follow directions. Notice something? The more you cooperate and fumble nervously, the more boxes they check, and the more boxes they check, the easier it is to arrest you. This is why you have a plan before you need it. Here's where it gets interesting. The law is actually on your side, and the officer hopes you never figure it out. Here's the part most people don't know. It is not illegal to drink and drive. It is illegal to drive and be intoxicated. Those are legally different things. Courts all across the country have been crystal clear about this. The odor of alcohol alone is not sufficient to establish probable cause for a DWI arrest. The Kansas Supreme Court said so in State v. Stevenson. The North Carolina court said the same in Atkins v. Moyet. Courts in multiple states, Tennessee, Ohio, Wyoming, Colorado, Wisconsin, Louisiana, Washington, have all reached similar conclusions. The smell of alcohol alone does not prove intoxication. So think about what that means. The officer's one move, I think I smell alcohol, is not enough by itself to take you to jail. But if you open your mouth and start talking, he now has everything he needs. Now, let me explain the framework real quick because you need to know what kind of encounter you're actually in. There are only 3 types of police encounters. Number 1, a voluntary or consensual encounter. The officer can approach you, you can walk away, no Miranda required. Number 2, a Terry stop. Based on reasonable suspicion, specific and articulable facts that criminal activity has occurred or is about to occur. Terry v. Ohio, 1968. Miranda is not required for a Terry stop. The detention must be temporary and use the least intrusive means available. Number 3, an arrest, which requires probable cause. And here's what shocks most people. During a traffic stop, police are not required to read you your Miranda rights. Miranda only kicks in when 2 conditions are both met. You must be in custody, not free to leave, and you must be actively interrogated. That is precisely why police do all their fishing before the handcuffs go on. Don't wait on Miranda to save you. Use your words to protect yourself right now on that roadside. But here's where it gets really interesting, because what I'm about to tell you could save you for a lot more than just tonight. This same approach, understanding the traps, knowing your rights before you speak, having a plan of action can be the difference between keeping your freedom and carrying a tainted criminal record for the rest of your life. Silence alone will not work either. And here's why. After Salinas v. Texas, the Supreme Court ruled that simply going quiet is not enough. Your silence can actually be used against you if you do not first explicitly invoke your right. So you can't talk yourself into an arrest. You can't just stay silent. What on earth are you supposed to do? Here are the exact words. Memorize them. Officer, I exercise my constitutional right not to answer questions about what I've had to eat or drink. Am I free to go or am I being detained? That's it. That's the whole thing. Screenshot this. Now let me break down why each phrase works legally. I exercise my constitutional right not to answer questions. That's your Fifth Amendment right at work. Once you've provided your driver's license, registration, and insurance, your legal obligation is done. You have no constitutional obligation to have any further conversation with that officer. I don't care how upset or frustrated he becomes about what I've had to eat or drink. Notice this does not mean you're refusing to talk to the cop. You're specifically declining this one particular topic, still polite, still specific, and with body cam rolling, there is no way he can write "suspect was combative" in his police report. Am I free to go or am I being detained? This forces the officer to commit. He now either has to let you go or he has to tell you you're being detained and then justify that detention. This puts the burden back on the officer, where it always belongs. Now here's the key. Say this calmly, respectfully, and as boring as possible. Boring is your superpower when dealing with the police. Flat, neutral, no attitude, no sarcasm, no energy. Say it like you're reading a grocery list. Let's role play this so you're ready if this happens tonight. I'm the cop. I think I smell alcohol. Where are you coming from? You officer, I exercise my constitutional right not to answer questions about what I've had to eat or drink. Am I free to go or am I being detained? Cop, hey man, if you got nothing to hide, just tell me what you had to drink tonight. You officer, I plead the Fifth. Am I free to go? Cop, refusing to answer makes you look guilty. That's suspicious. You officer, I once again exercise my constitutional right to remain silent, and I will not answer any further questions until my lawyer is present. And here's the mistake I see constantly. People say, I'll wait for Miranda, then I'll ask for a lawyer. Do not wait. Police often do not read Miranda at all, especially when they're still fishing for probable cause before the arrest. Invoke it yourself, proactively, out loud. Say, I also invoke my Sixth Amendment right to counsel. I want to speak to a lawyer before answering any questions. Fifth Amendment and Sixth Amendment, both, right now. And here's what is critical to understand. Your refusal to answer questions based on your constitutional right to remain silent cannot be used as any evidence against you. Invoking your rights is not evidence of a crime. Anyone who tells you otherwise is lying to you. But what if the cop doesn't like your answer? What if he doesn't like you standing up for your rights and demands you get out of the car for field sobriety tests? Under Pennsylvania v. Mims, cops can require you to step out of the car. That fight is settled law. Don't argue. Step out. But here's the legal jujitsu. As you step out, lock the door behind you. Press the lock button before you even get out. That locked door is a Fourth Amendment barrier. Now, for your decision on whether to take field sobriety tests, that is voluntary in every state, Let me be clear why that matters. You can be stone cold sober and still fail these tests. I've seen it over and over again. People blow 0 multiple times and still fail. Think about the walk and turn test. 9 steps heel to toe, 3-point turn, 9 steps back. What if you accidentally start before they say go? That's a clue against you. What if you do a 2-point turn instead of a 3-point turn? That's a clue. You only need 2 clues to fail the whole test. 100% sober, still failed. Then there's the horizontal gaze nystagmus test, the pen test. The officer moves a pen in front of your eyes looking for nystagmus, the involuntary jerking of the eye. But dozens of medications, medical conditions, and just plain nerves can cause the same response. And the officer decides, right there in the dark on a busy roadside, whether your eyes jerk too much. So what do you say? Officer, I only agree to perform these tests with my attorney present after the opportunity to seek counsel. Now, here is something that confuses people. Most states have what is called an implied consent law. By operating a vehicle, you have impliedly consented to provide a breath, blood, or urine sample if an officer believes you are intoxicated. But, and this is critical, the only penalty for refusing that test under implied consent is typically a driver's license suspension. It's a separate administrative penalty. It does not mean you have waived your constitutional rights. It does not mean you are required to take a field sobriety test. Know your state's specific implied consent law before you need it. And there are 2 very different breath tests. The handheld roadside breathalyzer, the portable breath test or PBT. In many states, that handheld test is not admissible in court to prove your actual intoxication level. It can only be used to establish probable cause for the arrest. The station machine and blood draws are admissible and are the primary evidence used to prove you're back at trial. And here is a critical defense point for your attorney. Police must prove your intoxication at the time of driving, not hours later. We have had clients where a blood draw taken 4 or 5 hours after driving showed a 0.09 blood alcohol level. That does not prove they were over the limit behind the wheel. In fact, if someone had several drinks right before driving, their blood alcohol level will be rising and may actually be higher when tested hours later than it was when they were driving. The further in time that blood draw is from the moment of driving, the less reliable it is as evidence of impairment while driving. Your attorney needs to challenge this timing. And here's a lie they'll use. This handheld test can only help you. It's just between you and me, it won't go to court. That is a flat out lie. That test is being used to establish probable cause for your arrest. Now let me show you the 3 mistakes I see over and over as a criminal defense attorney. Mistake number 1, just being honest. People say, I'm coming from Chili's, I just had 2 beers with dinner, I'm totally fine to drive. My friend, that sentence is now Exhibit A in the police report. Even if you are completely fine, you just gave the officer every reason to have you step out, do what I call stupid human tricks, field sobriety tests, and potentially arrest you. Don't even give them a reason to start. Mistake number 2, going silent without invoking it. This is the 5th Amendment loophole cops count on. After Salinas v. Texas, the Supreme Court ruled that simply going quiet is not enough. Your silence can be used against you if you do not first explicitly say, I exercise my right to remain silent, or I plead the 5th. Kind of stupid, right? I agree with you completely, but I'm not on the Supreme Court. You have to say the words. Mistake number 3, consenting to a search to prove you have nothing to hide. The moment you say yes, consent cures almost any issue. They can hold you on the side of the road and tear your car apart, remove seats, dump the glove box on the floor for as long as they want. And here's what you never think about. You don't know what other people have left in your car. A cousin who borrowed it last week, a friend who got a ride 3 days ago. I bet you $100 you did not inspect your car afterward. Never consent to a search. Now here's what's key. What if the officer pushes back? Because I guarantee you they will. Officers are trained to push. They get mad when they don't get their way. And that's okay. We don't get mad at the sun for rising in the east. 2 levels of response. Level 1, officer, I plead the 5th. Am I free to go? Level 2, officer, I once again exercise my constitutional right to remain silent, and I will not answer any further questions until my lawyer is present. And again, invoking your rights cannot be used as evidence of guilt. Anyone who tells you otherwise is lying to you. Now, I will say this again because it matters every single time. You will never win a physical fight with a police officer on the side of the road. It is not going to happen. Do not physically resist. If an officer proceeds with an illegal search after you have clearly refused consent, let them. Your calm demeanor is a strategic tool. If you can record the encounter and state clearly for the camera, I am not resisting, but I do not consent to this search. Sometimes trials are popularity contests. If you are in the right but acting a little crazy on the side of the road, that can go very badly for you at trial. I want my clients looking awesome on body cam. I want the officer looking like a jerk, not the other way around. And if it comes to an arrest, do not run, do not fight. The number one goal during any police encounter is to end the encounter and walk away safely. The fight is not on the roadside, the fight is in court. So here's a quick recap. Screenshot that checklist if you want it. 1, when the cop says, "I smell alcohol," remember, alcohol is odorless. Smell alone is not probable cause. 2, do not explain, do not apologize, do not offer your dinner timeline. 3, say the magic words, "Officer, I exercise my constitutional right not to answer questions about what I've had to eat or drink. Am I free to go or am I being detained?" 4, if he pushes back, "Officer, I plead the 5th. I want to speak to a lawyer." 5, invoke both the 5th and 6th Amendment proactively. Do not wait for Miranda. 6, field sobriety tests are voluntary. Officer, I only agree to perform these tests with my attorney present. 7, never consent to a search ever. 8, be boring. Be polite. Be silent. The golden rule during any police encounter: be polite, but be silent. The less you say, the more you are protected. You can be respectful to the officer while protecting your rights. Make no mistake about that. You've watched this far. Please like and subscribe and leave me a comment. I read comments 3 times a day, usually right when I wake up with some coffee. One time I read a comment so funny I spit coffee on my screen. I'm hoping one of you does that to me today. Tell me who I remind you of. I've gotten Tom Cruise, Joe Pesci, John Leguizamo, Turtle from Entourage. I'll take any of them. But what if you do everything right on this stop and then the officer pulls out his next trick? Check out this next video where I break down the 5 favorite tricks cops love to use during DWI stops and the exact words you can use to stop every single one of them. See you over there. Most importantly, and I believe this with my entire heart and soul, always plead the 5th.